An uncontested divorce is a process in which you and your spouse have an agreement on all of the issues. You or an attorney draft the filing documents, the uncontested divorce documents. Those include joint petition, agreement, some other documents, including your financial statement and your spouse's financial statement. So all of those documents are drafted, signed, filed with the court, and then the court will give you an uncontested hearing. You go into the uncontested hearing. Typically, unless it's grossly unfair, the judge will accept the terms and get you divorced. So an uncontested divorce is you have an agreement from the outset, fill out, file the documents, and then go to an uncontested hearing, and the judge approves the divorce. An uncontested divorce can last as long as it takes the parties to come to a full agreement and file the documents properly and go before a judge for the final hearing. So if the parties are in an uncontested divorce process, but there is an issue that needs to be sorted out, multiple issues that need to be sorted out, that can complicate the process and it can take longer. Generally, the easier it is to sort through the issues, the lower the stakes, the less complex the issues, the easier it is for the parties to get through the process. So it can happen very, very quickly, but if the parties run into issues, it can also drag on indefinitely in the worst case scenario, and it might make sense at that point to consider a contested divorce. A contested divorce is a standard divorce filing in the probate and family court in Massachusetts. And what's important to recognize is that in most cases, in the majority of cases, contested divorces turn uncontested as soon as the parties come to an agreement. So you can think of a contested divorce as a formal way to start the proceedings in a way that forces both parties to participate. So the contested divorce gets the case into the system. It obligates the parties to discuss, have negotiations, exchange information, and as soon as the parties come to an agreement, then the contested divorce changes into an uncontested divorce and the parties can finalize it. If they can't come to an agreement, then it remains on track for trial. Whether you can handle your contested divorce on your own really depends on your risk level. So think of it as a risk spectrum. On one end of the risk spectrum, you have a low risk divorce, which is very short-term marriage, no real significant disparity in income. You don't have children, so you don't need to sort out parenting time. You don't have a lot in assets. Then on the other end of the spectrum, you have a higher risk divorce, which is longer marriage, greater disparity in income, lots in terms of assets and the value of assets. And the further along that spectrum you are, and the closer you are to high risk, then the more sense it makes to at least get some input and guidance from a divorce attorney before going through the process. So if you are at the low end of the risk spectrum, then you really don't have a lot to worry about, and you can either do it yourself or hire a mediator to do it. The closer you are to medium and high risk, the more sense it makes to at least do a consult with an attorney and figure out what you're entitled to and how best to approach it before moving forward with a divorce. If you have any questions about contested versus uncontested divorce, feel free to contact us at Farias Family Law.